Thank you for joining us at Consumer Trial Lawyer Academy. My name is Nick Wooten. As many of you know, I've been practicing law for 26 years. During that time, I've always represented people against big companies, corporations, and in general, what I call the assholes of the world who are running over the average everyday American, taking from them, stealing from them, harming them, hurting them, and usually getting away with it. The purpose of Consumer Trial Lawyer Academy is to help you be a better lawyer, to give you confidence, to give you skills, to answer questions that you may have, to shorten your learning curve so that you can effectively represent your own clients who face these types of corporate defendants. And you can have confidence when you walk in the courtroom that you're actually ready to go and you've done what you need to do to present your case in a powerful way. So, if you like our content, you like our videos, please like and subscribe. Feel free to throw in some comments on any topics you'd like for us to discuss. We would love to hear from you and work on ways we can make our products better for you. Today I want to talk to you a little bit more about the topic of expert witnesses and the different ways you can potentially handle experts on a low budget, so you don't have to spend tons of money dealing with defense lawyers and their hired stooges. So we've talked about the portions of trial going all the way through to where you rest your evidence, and I wanted to come back and talk specifically about the topic of expert witnesses. And the reason that I want to talk about expert witnesses is because, there are a lot of ways to deal with this issue. Every state has their own rules about what defendants must disclose with their expert witnesses. Federal court obviously has 26A2B and all of the subparts. And so, if you're going to trial and the other side has witnesses, then, you have to decide how you're going to handle those folks. If you read the textbook of quote unquote being a trial lawyer, people who do it by the book, whatever the hell that is, they would tell you that, when you get an expert disclosure, what you're supposed to do is read that disclosure and you go investigate this expert and you spend $2,500 on a service that goes and looks at everything he's ever written, everything he's ever testified to, and they look for, angles of attack on those fronts. They look for possible ways to, disqualify that expert. And they, gather this giant dossier, and you spend weeks of your time more or less going through this, and then you notice this expert's deposition, and then you go and you take this exhaustive deposition about all these things, and you test everything that he has to say, and you look for ways to impeach him, and you look for ways to disqualify him, and you spend tens of thousands of dollars and potentially hundreds of hours of manpower on this expert. That's certainly one way to do it. Can't say that that's wrong, right, or otherwise. I can say that in my career, I have not often had either the time or the money to take that attack, and haven't always found that it's really successful. And in my experience, a lot of times that angle of attack lends itself to playing on the defendant expert's field. In other words, talking about the things that they want to talk about, talking about the areas that they are concerned about, talking about the things that actually help them. And if you know me, I don't really give a damn about helping the defendants do anything, and I certainly don't give a damn about their experts. So, I have sort of my own philosophy on this topic, and I do it differently than a lot of people, and so my first analysis always begins with, is this deposition of this expert even necessary? And when I say that, I look at this from the perspective of I'm going to trial. So what do I know about my evidence? And, if I'm going to trial, I know that my evidence proves my case. So then I'm looking at, what does this expert give the defense? What does he give them? Does he give them an opportunity to defeat my case? Does he give them an opportunity to diminish my damages? Does he give them an opportunity to do both? Does he give them a distraction? What does he actually give them? And, once I've decided what that expert actually gives them, then I can decide, what's the best way to handle this. Again, most plaintiffs' lawyers put on their case and they leave the defense lawyers' experts alone, and then the defense gets to stand up and they call their experts and they put on this very scripted, polished show of what this expert's opinions are, and and the experts got this smooth talking, well rehearsed, well coached testimony about why you don't have a case or you're not injured or whatever. Folks, that's about the worst possible way to do anything. Remember, this is a trial. This is not, a gentleman's soiree. I mean, you're trying to win your case for your client. You are not trying to play by anyone's rules. You have rules of evidence. You have rules of procedure that you have to follow. You have scheduling orders you have to follow. But how you present your case is your own within those broad parameters. And personally, for me, I like to leave defense lawyers as frustrated as possible. And the best way to do that is to leave them nothing to do but sit over at their table and scribble on their notepad. And the way you do that is that you take all the witnesses at trial. You never let them call a witness at trial. If they're calling anyone, you want them to be recalling someone that you've already dealt with during your main case. So, a lot of times I will take the expert's report and I will read it and I will understand what it is they're hoping to say. And then I will call their expert at trial. And I'm not beyond calling their expert at trial as the first witness. I just recently did that in a case against a large financial institution. And I had their quote-unquote banking expert on the stand for most of the first 2 days of the trial. And the time that he wasn't on the stand, I had an expert that I had called that they had retained to do an independent medical examination of my client. But because they didn't like his findings, they didn't want to call him as an expert at trial. So I subpoenaed him to come and testify at trial and basically show that Wells Fargo had hired him to examine my client, and when he gave them their report, they no longer wanted him to testify. And the reason they didn't want him to testify is because he said, this person's hurt. And so, we resolved that case 3 days into the trial, and we never called a real fact witness. All we dealt with was experts. So, is that unusual? I think everybody's head in the room exploded that was not on sitting at my table when I told the court that I was calling the defendant's experts as the first witnesses at trial. The lead trial lawyer for the defendant stood up to court and said, well, that's very unusual, Judge, but I guess he can do it. Well, hell yeah, I can do it. Nothing says you get to call your own expert when you want to. If you designate him as an expert, then I will slap a subpoena on him, and I'll bring him to court, and I'll throw him on the stand, and I'll never let him tell the story you want him to tell. Just not going to happen. When I was a younger lawyer and less experienced, I thought that I had to follow the playbook. I thought I had to let people put on their case No, absolutely not. Put on the case in a way that suits you and your client best. And sometimes that is to take their quote-unquote experts on. And, I'd put their medical expert on knowing that the actual treating physician was going to come afterwards. And why did I do that? Because I wanted the actual treating expert to be able to come in afterwards and talk about what was wrong with their quote-unquote experts' opinions. And can't do that if you play by the playbook. You put your expert, you put your treater on, and then they sit up and criticize your treater. No, we don't do things that way. We do things in a way that get the outcome that we want for our clients. And the way we want that to happen is we want to control the story that's told. We want to control the evidence that flows to the jury. We want it to flow in a way that tells the story that we're telling, not that they're telling. Because we're the plaintiff. We have the burden of proof. We have the opportunity to do so. And so the other point is that for those of you that know me, you understand I'm a little bit of an odd duck when it comes to being a trial lawyer. I don't do things like other people do things. I'm, hard to see with my hair slicked back in the video, but, I'm kind of a long-haired redneck and typically wear cowboy boots and try cases up north and in the Midwest, and my accent's a little funny, and, all those things are different in that part of the world. And, a lot of these experts are super highly educated and went to fancy schools with big names, and, they've never met me. A lot of them never met anybody like me. And the last thing I want to do is get them comfortable with who I am and what I am. And if I go take a deposition for 8 hours, they're going to give a sense of who I am and what I am and how I think and how I operate. Quite frankly, that doesn't benefit my client at all. It's an exercise in mental masturbation. I'm trying to prove that I'm smarter than some expert. I don't care whether I am or I'm not. I don't need to prove anything. What I need to do is win my client's case. And the way that I do that is that I make sure that I present the evidence in a way that's going to win my client's case. And that is not to give the defendant any quarter. I'm not giving them the opportunity to do anything that they want to do. I'm going to make them pick up pieces. I'm going to take their little China doll and I'm going to hit it with a Louisville Slugger and I'm going to spray it all over the room. And then I'm going to let them get out there, super glue and try to glue the pieces back together. And, if you think of their little story in that context, they have this little China doll that they've built out of lies. And they want to present this pretty little China doll to your jury. And what you want to do is pitch that China doll up in the air and hit it as far as you can with a Louisville Slugger and see if you can spray it from here to Timbuktu. That's basically what you're trying to do at trial. And so dealing with experts is one of the things that you have to do to be able to blow that little China doll story up. And you have to figure out what's the best way to do that. For instance, in the recent case, the expert was testifying, but they had hired a company to prepare the report that the expert signed off on. It was testifying too. So the expert never actually bothered to read the report that they had prepared. You can imagine how that went. When you're citing for authority some Indian fella named Baloo from a blog for authority on computer technological network security, and you don't know whether Baloo is from Bangalore or Blue, Montana, because you don't even have a last name for Baloo, B-A-L-U. And the blog is like off of something that looks like a cereal box. And, no one's credentials are there. No one can verify the authenticity of what's been said. Or you have, you cite to a 50-page Federal Reserve paper and you pull out one abstract sentence, but the overall gist of the 50-page paper is that what you're doing to people in this case is wrong and you ought to be, corporately executed for it. But you didn't read that paper, so you don't understand it completely contradicts everything you're trying to say. Those are things you can do when you have prepared to take on the experts, but you haven't told them how you're going to attack them because you haven't gone to a deposition and educated them on all the problems with their opinions and their testimony and their supporting materials, so that they can clean up a story to come to trial and try to explain those types of things away. Remember that while we don't get to do much by way of trial by ambush, the idea that you have to go educate a defendant about the problems with their case and their experts, that's one thing you can avoid by choosing to go at it a different way. So consider whether you have to take the expert's deposition. There are times when it might be necessary if the expert is someone whose opinions could be outcome determinative and you need to head that off to avoid a summary judgment motion. That's one concern. But when you know you're going to trial and you know that this expert is not someone who's dispositive, they're rather someone who's trying to excuse the misconduct, you don't have to depose that expert. You don't have to contradict them by impeachment. And even when they're dispositive, if you have your own counter experts, then you have no undisputed facts to base opinions on. So, you don't have to deal with that. So remember, if you know you're going to trial, get the experts in the format that's most effective for winning at trial. Take them direct. Don't let the defendants get them on the stand and let them talk through how smart and how glorious they are. Get them on the stand. Say, hey, these assholes hired you to be an expert in this trial, right? They say you're an expert in whatever subject, right? And that's what you say. You're an expert. And you're here as a paid witness to talk about X, Y, and Z, right? And your opinion is you want to tell this jury 1, 2, 3. Well, let me ask you a couple things about that. That's definitely, in my opinion, a much better way to address the expert issue, especially when you know the expert's going to testify and you know you're going to trial. It's one thing if you know you can knock the expert because of inadequate disclosures or lack of qualifications or some other issue. But when you know you got to deal with them, you know they're coming to trial, and you know you're going to trial, you got to deal with them in a way that helps you win. And the best way to do that is to beat that expert and disarm that expert on your terms and your way, and not let that expert be walked through a series of questions. It's going to make them sound like some kind of freaking rocket scientist who's speaking from on high with an infallible opinion. You've got to put them on the stand and you've got to poke holes in what they're doing before the defendant gets a chance to bolster them and make them sound like they're some demigod or something. So think of those things when you're thinking about how to deal with experts. Think about whether it's better to keep that expert in the dark about who you are and how you're going to handle them, rather than go sit down with them for a day and a half and let them find out all about you. Because a huge part of being able to deal with these experts is the idea that those experts are no more comfortable in the actual courtroom in front of a judge and a jury than any other witness. A lot of those guys are very used to sitting in a conference room and being deposed. But the majesty and the significance of being in that courtroom and having 12 jurors looking at them and having a judge staring down at them and knocking them off their script creates a scenario where you oftentimes get concessions, statements, and opinions that are different than what's in their report. And the bottom line is all you got to do is poke some small holes in what they're saying to unwind everything. And on top of that, you still have the bottom line that those folks are taking a lot of money to come and say what the defendant wants them to say. And so if you can blow holes in their statements and their opinions, coupled with the fact that they're getting paid a bunch of money to make it, or you can demonstrate that they're relying on documents they've never actually read, you can really make hay with those types of witnesses in a way that can help your case. And oftentimes you can get statements from those people when they're unprepared for you that actually help your case and bolster your case rather than harming your case and hurting your case. So don't be afraid to throw the book out the window when the book doesn't serve your needs. Remember, your obligation is to present a winning case. Your obligation is not to do something the same way everybody else does it because someone said you should. Do what wins. And if that means do it exactly opposite of what the book says you're supposed to do, so be it. It's your level of preparation and your willingness to do the work that will prepare you to take those people on in a way that you can be successful. If you make the commitment and you put any time and effort to get ready, you can take them on anywhere, anytime, any place, and you can take them on in a way that will help your case. But if you don't put in that time and effort and make that commitment, then it doesn't matter how you handle them because they're going to spank you all over the courtroom because you're really not ready. So do your work, put them on in a time and in a way that helps your case. Ignore the book if it doesn't serve you. Thanks again for sitting through this with us. I hope it's been informative and helpful. I hope you find it useful. And I appreciate you taking the time to watch the video with us. And if you like what we're doing here, please like and subscribe, share with your friends. We appreciate the people who are already subscribing and watching videos. Looking forward to building an audience and helping guys and gals out there who are working for normal people be more confident in what they're doing and be more effective in what they're doing. And appreciate any questions or comments you might have. I look forward to many more episodes, Consumer Trial Lawyer Academy. Thanks, and join us soon for another episode.